So new unit this week, we're going to talk about criminal law. This will just be a 1-week unit, so I'll lecture mostly today and then Thursday. If I have any lecture to finish, I'll do that, and then we'll have a case to discuss, maybe some examples to discuss on Thursday, and then you'll have a quiz over criminal law next Monday night. Any questions on that? No questions on where we are. Everybody caught up? There is a discussion question this week, so don't forget about that. We're getting on probably near halfway through, but you're not going to have you don't have a midterm or anything like that in here. We just keep on rolling like we have been with just a quiz every week, pretty much. I know y'all, spring break is coming up in 2 weeks, 3 weeks, 14th. So we have this week and next week, and then you go on spring break? Okay. Then I think y'all come back, and then I think I go on spring break, and then we'll finish out April. We finish class like the end of April, I think. I don't think we go too deep into May, so all that is good. All right, so that's where we are. We're going to talk about criminal law today. So the last unit we talked about tort law, and remember, tort law is civil law. We divided, at the beginning of the semester, we divided the law up into civil law and criminal law. Most everything we talk about is going to be civil law, except for this week when we're talking criminal law. So we're going to switch gears in our brains a little bit. And I want you to remember the differences between civil law and criminal law. So in civil law, the burden of proof at trial was preponderance of the evidence, more likely than not. In criminal law, the burden of proof is beyond a reasonable doubt. Okay? That is not the same thing as without a reason, with no doubt whatsoever. It's not 100%, but it's if there's really no other reasonable explanation, then the defendant did it. The jury would find that person guilty of the crime. So in civil law, we talked about liability. The defendant might be liable. In criminal law, the defendant would be guilty. Another difference in criminal law and civil law is that criminal law can carry with it harsher sanctions than civil law. Civil law, remember, is designed to compensate the injured party. It's mostly monetary damages. Criminal law, the state is not so interested in the defendant paying restitution, although that is part of criminal, that is a possible sanction. It's more interested in punishing the defendant for the conduct that is contrary to society and in deterring other people from committing the same crimes. All right, so different goals. What explains, do you think, the difference in the burden of proof between criminal law and civil law? Civil law is a lower burden of proof. Criminal law is a lot higher. Why would that be? The stakes are higher, right? Exactly. The sanctions in criminal law are higher. The worst, the most severe sanctions in criminal law would be death. Won't have that very often, but that is on the scale of punishment, that is the most severe. But it also involves loss of liberty, jail time, things like that. And if we're going to take away those freedoms, we want to be sure that at the trial, the jury was convinced that the person did do this. We don't want to put innocent people in jail. All right, crimes can be classified as felonies or misdemeanors. Felonies are the more serious crimes, usually punishable by more than a year in prison. And then misdemeanors are your lesser crimes that are usually punishable by less than a year in prison or by just a fine. Remember in tort law, when we would take each individual tort and we would look at the definition of that tort, and the plaintiff would have to prove each element of that tort. Similarly, in criminal law, we look at the definition of the crime, and the state, if it's a state crime, or the federal government, if it's a U.S. crime, would have to prove every element of the definition of that crime. All right, crimes are going to require some sort of act or omission. Call that the actus reus. That's the Latin term for that. And crimes are going to require a certain state of mind. Call that the mens rea. Okay? So the prosecution is going to have to prove that the defendant did the criminal act and also that they had the requisite mental state when they were doing it. Mental states can range from intent all the way down to strict liability. Remember, strict liability is you're guilty no matter whether you intended it or not. So I'm going to go down sort of the scale of the different levels of state of mind or mens rea that you will find in criminal statutes. Obviously, intent means that the person meant to do the act. Murder, the intent was to take the life. That's why when you see someone take another's life accidentally, they're not being charged with murder, because that murder statute defines murder as the intentional taking of the life of another. It doesn't mean you're off the hook if it was an accident. It just means it's a different crime. Okay, so crimes are going to have different definitions about what acts are required and what the state of mind is to meet them. A little less than intent is recklessness. Some criminal statutes don't require that you intended it. They just require that you disregarded a known risk. Okay, that you were reckless. I didn't mean to kill another motorist, but I was driving 200 miles an hour down Macon Road. They probably can't prosecute me for murder, that I don't have the mens rea, I don't have the state of mind required for murder. But if there is a criminal statute that requires recklessness as the state of mind, they probably could try me on that one. Negligence, okay, we're going to borrow that a little bit from tort law. We spent a lot of time on negligence last unit. Negligence can also be the mental state in a criminal statute. I had a duty, I breached that duty, the consequences of my breach were foreseeable. I might be liable, or be guilty if the statute just requires negligence as the state of mind. Strict liability, that does not look at all into intent. It doesn't require any of the levels of intent from recklessness, negligent, all the way on down. Strict liability means you did the act, you're going to be guilty of the crime no matter what your intent was. An example of strict liability would be like if the crime of statutory rape. So that is when a person over the age of 18 has sex with somebody under 18. If the act happened, the intent doesn't matter under that crime. The statutory rape statute just says, in order to be found guilty of that crime, all you had to do was do the act. You didn't have to know they were underage. That didn't matter. That's an example of a strict liability crime. Just like in tort law, strict liability is not, you don't see that very often. Our justice system is set up to where we want to punish people when they've knowingly done something wrong, right? We don't go around generally charging people with crimes and throwing people in jail when they had no intent to do something wrong. But there are certain crimes that only require strict liability. We can have criminal law on the federal level. So U.S. Congress can pass laws that establish federal crimes. We have crime on the state level. State legislatures pass statutes that criminalize behavior as state crimes. We could have local crimes. Our city council could pass some criminal laws. So there are federal crimes and state crimes. If I'm arrested and accused of committing a federal crime, what court system am I going to be in? The federal court system, that's right. If I am arrested and accused of a state crime, I'm going to be in the state court system of whatever state it is who's charging me. Remember, in civil law, the plaintiff is a private individual or a corporation. In criminal law, the plaintiff is the government. Private citizens don't get to enforce criminal laws. Only the government can do that. So if I violated a federal criminal statute, that case would be United States of America versus Tebow. If I violate an Alabama criminal statute, that case would be State of Alabama versus Tebow. All right, any questions on state of mind? So corporate criminal liability is the next thing I want to talk about. We tend to think sometimes about, when we think about committing crimes and being punished for crimes, it's easy for us to conceptualize, well, I got arrested, right? I'm in jail. I had a trial. I got a prison sentence. But what about for companies and corporations? They can still commit crimes, okay? They're not exempt from that. So a corporation, even though they can't be put in prison, they can be denied certain legal privileges. They can be held liable for crimes committed by their employees or their officers if it was within the scope of employment. And even if a supervisor or a manager or an owner didn't know what their employee was doing, but they should have known, they might have some criminal liability themselves. Same thing goes for boards of directors. Like let's say I sit on the board of directors of Money Bank, and the president of Money Bank is operating this huge embezzlement scheme, and I should have known about it in my position on the board of directors. If I had done my due diligence, if I was paying attention, I would have figured it out. I might be liable for that as well. The types of crimes we're going to talk about, I'm going to go a little bit fast through violent crime and property crime because they don't have as much relevance to business law as some of the white collar crimes. But I still want you to be familiar with how these crimes work and to pay attention to the definitions and the elements of these crimes so that if you get a fact pattern later on and you're asked, what possible crimes has this person committed, just like we did in the tort fact pattern with Johnny and Rusty, that I want you to, that same thought exercise. How is this crime defined? Can I take these facts and make it meet any of these criminal definitions? We have violent crime. Everybody's familiar with murder, sexual assault, assault and battery, robbery, things like that. Those are classified generally by degree. You'll hear like murder in the first degree, murder in the second degree, theft, grand theft, petty theft. The degrees of crimes usually have to do with the severity of the injury or sometimes the money value, like stealing a Lamborghini that's worth $100,000 might meet the definition of a higher class of crime than if I stole somebody's tricycle. So the crimes have different levels of degrees that carry with it different punishments based on the severity of the conduct mostly. Property crimes. These have some relevance to business law. Burglary is the breaking and entering the building of another. Like that's the definition of burglary. What you don't see in the definition of burglary is the taking of something. We tend to think of burglars as people who steal stuff. But in the legal definition of burglary, it does not include taking anything that belongs to anybody else. It's just the breaking and entering of premises that belong to another. So I guess like the Hamburglar is not really a burglar. Unless I guess if he broke in McDonald's, then he could be the Hamburglar that way. Y'all don't know the Hamburglar? He's a retired McDonald's. They don't use the Hamburglar anymore. Anyway, he steals hamburgers. Larceny is the wrongful or fraudulent taking and carrying away by any person of the property of another. So that's what we think of as theft. Larceny is the actual theft. A lot of these crimes can go together, right? If I break into McDonald's and I steal the hamburgers, I have committed burglary and larceny. Obtaining goods by false pretenses. If you obtain somebody else's property or goods by tricking them or by fraud, this often applies in the commercial context. That could be obtaining goods by false pretenses. It's a crime to receive stolen goods. Okay, even if you're not positive that they're stolen, if you should know or should have a good idea that they were stolen or illegally obtained, you might be guilty of the crime of receiving stolen goods. If I'm walking down the street and Elrod is like pops his trunk, he's like, "Hey, you want to buy a Rolex?" And I'm like, "Dang, are these real Rolexes?" Like, "Yeah, they're real Rolexes." I should have some idea that that's not above board, right? I mean, I know Elrod, and I don't think he would sell stolen property, but brand new Rolexes out of his trunk is a little shady, right? So it's not enough just to say, well, I don't know for sure that they're stolen. Arson, that is when you set fire to a building or another structure. Forgery, this does come up in the commercial context. Forgery is the fraudulent making of any writing that changes the legal liability of another. You know, forging a check, forging a contract, changing a contract. Y'all miss this is something that my generation was very good at. We could forge grades and notes to teachers and stuff because it wasn't all electronic back then. Not that I did that. Public order crime includes public drunkenness, prostitution, gambling, illegal drug use. And then we get to white collar crime. So this is more relevant to business law. White collar crime is committed in the course of a legitimate occupation. So the occupation itself is not criminal. It's a legit business, but there's some sort of criminal activity going on within the legit business. Embezzlement. That's when an employee converts property, owned by one person, usually their employer, but it's entrusted to another, and they keep it for their own, or they have possession of it for a period of time that deprives the real owner of it. If I'm running the cash register at Steak and Shake, and every time somebody pays cash, that goes in my pocket, that's straight up embezzlement. Okay. If I am working at a car dealership and somebody brings in a cash payment and I put that money in my pocket because it's 4:30 in the afternoon and it's getting late, and I'm going to turn it in to my employer in the morning, but I just take it home with me, that's embezzlement. Even if I intend to give it back to them at another time. Me having property in my possession that belongs to somebody else in the employment context could be embezzlement. Mail and wire fraud. So this is when a person commits any crime using electronic means or the mail. We won't see it in the U.S. mail as much anymore. Wire fraud used to be that mail fraud was much more common than wire fraud. Right now, wire fraud is much more common because we don't do anything by regular mail much anymore. But these scams that you get in your email inbox, I bet everybody could open up their email right now and find an example of wire fraud. Even if the crime is, let's say that the crime is murder for hire, and Ms. Hernandez hires me to kill her enemy, and I do it, and she Venmos me $10,000. That could be wire fraud. We've committed the transmission of money is part of the crime we committed. So they might throw wire fraud in there as well. Wire fraud today could be pretty common just because of how we use electronic means for everything. Bribery. Bribery of public officials is a crime. Okay? The crime is offering the bribe. That's key to remember. The crime is offering the bribe, irrespective of whether the person accepts it. If the person accepts a bribe, they're also guilty of a different crime, accepting a bribe. But if I go up to the mayor and say, I will give you $20,000 to take my name off the property tax rolls so I don't have to pay property taxes anymore, and he says, you're crazy. I could never do that. That's criminal. I could be arrested for bribery because I tried to do it. I offered the bribe. That's the crime. Doesn't require that it was accepted. Bribery happens in the commercial context also. Payoffs, kickbacks, things like that. I'm a salesman. I go to this business, the tire shop, and I'm like, hey, y'all carry my tires. I will give you, $1 for every tire that you sell. It's one of ours. That would be commercial bribery. If I am inducing someone to do something that's not in their employer's best interest, but it's in their own best interest, they're personally profiting from it, then we might be looking at some sort of commercial bribery. It is a crime to bribe business persons in other countries. That's a little bit problematic for U.S. companies operating abroad because there's some countries where that is standard business practice. You got to pay off somebody if you're going to be successful in that in that country. But it is illegal to do so in this country. Bankruptcy fraud. When you file bankruptcy, there are two kinds. You can file bankruptcy where you just want to reorganize and then start over again. And then some people file bankruptcy where you're like, I'm out. I'm liquidating everything. I'm not going to try to reorganize and reopen. When you go through either one of those processes, you've got to turn into the bankruptcy court a detailed list of everything you have. Its value, your accounts receivable, your equipment, any asset that you have has to be listed, value has to be listed fairly. So anybody who fraudulently represents any of that information to the bankruptcy court, that could be bankruptcy fraud. Or some people will be like, hey, I'm fixing to go in bankruptcy. I'm going to deed you this property over here so it won't show up on my bankruptcy. Or I'm going to, give you this money that I've been hiding in my bedroom. You can give it back to me when the bankruptcy's over. Things like that are bankruptcy fraud. Theft of trade secrets. So trade secrets is a form of intellectual property that businesses own. It could be their customer lists. It could be their recipes, like the formula for Coke, or my mailing list, the Colonel's 7 blend of secret spices or whatever it is that KFC has. Manufacturing processes, a design, things that are personal and are owned by that business that are not public. It would be a crime to steal those from another company. Theft of trade secrets. Insider trading. So You actually seen some decently high-profile people prosecuted for insider trading, like Martha Stewart went to jail for insider trading. That is when a person buys or sells stock based on information that they get that is not public, right? So all of you finance majors, you learn that the underlying theory of securities trade is that everybody trades based on the same available information. Okay? Public information is what we can make our decisions to buy or sell stock on. If we're making decisions based on information that the public doesn't know, that's not fair. All right, so the system is set up that if anybody is making these trades, they're doing so with the same knowledge or with the same ability to collect the public knowledge that everybody else does. Insider trading happens when somebody knows something that's not public and they act on it. Like I saw, I don't think this was true. I don't know that this was true. But I saw I don't know what social media I was on, but it's something like, why did the Trump family buy 1 million shares of Chevron last week before we attacked Iran or something like that? That would be an example of insider trading. I'm not saying they did that because I don't trust any headline that I read anywhere. But if a government official was part of a private briefing where they're like, hey, we're fixing to attack Iran and it's going to cause the price of oil to go way up, so all these oil stocks are going to increase in value, and let's say Senator Tebow was part of this private briefing, I go out and I purchase shares of Chevron based on that private information that I got, that would be insider trading. Okay. Employees of businesses. If I work for a pharmaceutical company and we are just about to, we're about to get approval of a drug that cures cancer, I'm going to go out and I go out and I load up and buy as much of that company's stock as I can. That's insider trading because I know something that the general public doesn't know. So officers of companies, CEO, mostly the executive level of companies, they're required to disclose their stock trades to the government. And those would be scrutinized to see if the timing was suspicious on any of those. So anytime CEO, CFO, board members, large shareholders of a certain company make any trades, they have to disclose it. Members of Congress have to do that too, to make sure that they're not trading based on classified information that they're getting in defense briefings or in some sort of private briefing. Okay. If my brother was president of this company and they had a patent that was about to be approved and it was going to be a big deal for them profit-wise, and he was like, hey, bro, you need to go load up on our stock, and I bought some, that'd be insider trading. If I'm sitting at the Little League game in the bleachers and I hear some guy behind me who's president of Synovus talking on the phone, and I can overhear that they're getting ready to merge with another bank and that's going to boost their stock price, and then I go home and make a trade based on that knowledge, that's insider trading. Is it likely that anybody would ever connect those dots that I made that trade based on what I heard in the bleachers? Probably not. But that is still insider trading. Anytime you buy or sell stock based on information that is not public, that could be insider trading. Organized crime. We're all familiar with this in some form or another. This is mafia activity, racketeering activity. Organized crime is when some of those white collar crimes we were talking about a minute ago, those were legitimate businesses that might have had something illegal going on within them. Organized crime and racketeering, that in those situations, the business is crime. Like that is what we do. We're a criminal enterprise. That's our business, is that we commit crimes. Money laundering is one way that you see this happening. And that is when money from a criminal enterprise is laundered or cleaned by running it through a legitimate business. Right? I own a pizza parlor, and I also deal cocaine. Right? I get paid cash for my cocaine. I put that in the cash register of my pizza parlor, and I count that as pizza sales. That's money laundering. I'm taking dirty money and I'm cleaning it by running it through a legitimate account. Conspiracy is a crime as well. And conspiracy does not require that each person actually did the crime. Conspiracy only requires that you were involved in a step in planning the crime or carrying out the crime. I drive the getaway car, but my gang, we all sit down and we're like, all right, you're going to do this, you're going to break in, you're going to this, I'll drive the getaway car. I might be charged with the crime of conspiracy to commit robbery because I was a part of it. Doesn't matter that I wasn't the one that went in the bank with the guns, took anything. All right, so conspiracy is a different crime than robbery. Let's say that my gang did all that. Are we going to be charged with more than just conspiracy? Yeah, they're going to charge us with armed robbery and theft and all these other crimes. Just like in tort law, you could take the facts and try to see how many torts apply. Same thing for criminal law. Somebody's committed a crime, the government's going to look at all the different all the facts of that and circumstances of what went down, and they're going to see how many crimes they might make those facts fit. So it's very rare that somebody would be charged in a large-scale operation with just one little crime. There are a lot of different ways for them to try to get you. All right, cybercrime. I feel a little bit guilty that we don't talk about cybercrime more because it's just such a huge area, but it's also an area where I think it's hard to talk about in concrete terms. It's changing all the time. It goes over my head, I guess is what I'm trying to tell y'all. We have any cybersecurity majors in here? No cybersecurity majors? I should probably get them to come and talk sometime about cybercrime. Maybe we'll have a guest speaker toward the end of the semester on that. That might be interesting. So I just don't get too deep into that in this unit. Defenses to criminal liability. So justification is a defense. So remember, on these defenses, the defendant has been charged with a crime. These are defenses that person who's charged might raise that would negate some element of the crime or negate their responsibility for the crime. Okay? Justification. If Miss Landrum comes at me with an automatic rifle, okay, and she's walking down the steps here and she says, prepare to die, okay, and I pull out my gun and shoot her, and I get charged with some sort of crime. I can think of a few crimes that I might get charged with for shooting her in a classroom. Okay? One of my defenses might be justification. It was justified that I did it to prevent myself from being harmed or other people from being harmed. Justification is a little bit tricky because most states will say you're allowed to use an amount of force that is necessary to protect yourself, your dwelling, or your other property if you believe that imminent death or great bodily harm will otherwise result. if the attacker is using unlawful force, if the defender did not provoke or initiate the confrontation, and the force has to be commensurate with the threat. So if someone were to come in here with a slingshot and announce to the classroom, prepare to die, and I take out my automatic weapon and I put 50 bullets in this dude, okay? I get charged with the crime and I go to trial and my defense is justification. I'm going to have some trouble with that, right? Because was the automatic rifle a reasonable, commensurate force with the threat that was presented? I was a little bit more, right? A little bit more. It's going to depend, of course, on the facts and circumstances of each case. But I'm going to have trouble convincing the jury that there was a reasonable belief of imminent death or great bodily harm. And I'm going to have trouble convincing the jury that the force that I used was proportional, commensurate with the threat. Okay, so I don't just get to blow away anybody that I think is coming at me. It doesn't have to match exactly. It doesn't have to be like knife for knife, gun for gun. Okay, it's going to depend on the seriousness of the threat, the means that were available to the person. Yes, ma'am. What is unlawful force? That would be, you mean in the context of justification? Yes, like is that just having a gun? So I think that the way that would be looked at is that somebody, unlawful meaning illegal, somebody was coming at you with illegal force, trying to attack you. That it's illegal to attack people. It's illegal to point guns at people, things like that. I'm trying to think of what wouldn't be unlawful force. You know, if protesters were outside the business school protesting something and it's a peaceful protest, but there's 1,000 of them and I'm trying to get in my car and I got to walk through them, I can't open fire on them. There was no unlawful force coming my way. Does that make sense? Good question. I know you think you're not going to law school, Delaney, but I think you are. Tell your family. Necessity is a defense sometimes. If the criminal act was necessary to prevent an even greater harm. I'm walking down the street, downtown Columbus. It's late at night. I see a fire in the store. I take a crowbar and I shatter the glass. I go in there so that I can put the fire out. If I'm charged with burglary, right? Burglary is the unlawful breaking and entering. I might use the defense of necessity. Yes, I did that, but I did it to prevent the place from burning down. I have a hard time thinking that I'm going to get arrested and charged with burglary if I've done something like that, but it's an example. Yes?
Another example of that one is I remember there was a hurricane occurring and someone had broken into a gas station so that people could shelter inside. And honestly, he was going to be charged, but he basically said that I was trying to break in so that people could take.
Well, that's a great example. Somebody broke in to a gas station during a hurricane so that people could shelter inside. Yeah. Necessity. I had to prevent a greater harm. Insanity. Why is insanity a defense to a criminal act? What does insanity negate? The state of mind, right? So we said at the beginning of the class, in order to be charged, convicted of a crime, you have to have done the criminal act and you have to have had the requisite state of mind. well, I can't have the state of mind if I was insane. I didn't appreciate, I was incapable of appreciating my actions or what I was doing. Insanity is not easy to prove, as you might guess. A person can be, they can be insane to the point of being incapable of understanding what they're doing for a certain time period and then be fine. The ones that are easier to prove, I think, are the ones where a person has a long documented history of some sort of mental illness or developmental disability that it's been diagnosed and documented, and we know that that person really doesn't have the ability to appreciate what they're doing. The temporary insanity ones are a little bit harder. Heat of passion, you see that defense? That's akin to insanity. I lost my mind temporarily. My emotions got the best of me. That's not really going to be a defense. It might mitigate somewhat, but it's not going to be a defense in the way insanity is. Any of these defenses that we're talking about, the defendant has to prove those, right? So we talk all the time about how the plaintiff in a civil case has to prove all the elements of the case. The government in a criminal case has to prove all the elements of the crime. But it's not, the defendant doesn't raise his hand and say, Judge, I was insane, and they got to prove I wasn't. The defendant, in order to use a defense, has to prove the defense himself or herself. Mistake is a defense. But I want you to appreciate this as a distinction. A mistake of fact can sometimes be a defense. I'm at the market days in downtown Columbus on Saturdays, and there is a person selling homemade flour. Okay? They're advertising they're selling homemade flour. I buy a brick of flour. It turns out to be cocaine. All right? I get charged with possession. I could use the defense of mistake of fact if from the circumstances I could prove that I thought it was flour. Okay? So when I tell you that mistake of fact can sometimes be a defense, it's not enough just to say to the arresting officer for any crime, oh, I didn't know the speed limit was 70. Or I didn't know that you can't just deny knowing what it is. In other words, you can't make up a mistake of fact. I'm not explaining that very well. But I want to contrast that with mistake of law. It is never a defense to say I didn't know that was illegal. Never a defense to say I didn't know that was illegal. That's also important in other countries too. Well, other states. We go to other states. We might not be as familiar with their state laws. Certainly other countries, we might not know what may or may not be illegal over there. You go to another country and you commit a crime there and you say, well, I'm sorry, I'm foreign. I didn't know it. That doesn't work. So mistake of fact is sometimes a defense. Mistake of law is never a defense. I'll try to do mistake of fact better. Let's say that I go to my dealer, my cocaine dealer, and I buy cocaine from my dealer, and I'm arrested and charged with possession. I can't tell the officer I thought it was flour, right? I'm not going to be able to convince a judge or a jury that it was reasonable that I thought my cocaine dealer was giving me flour. So mistake of fact, sometimes a defense. Mistake of law, never a defense. Duress. Duress is when somebody commits a crime because they were threatened into doing something that they otherwise wouldn't do. Duress would excuse the crime if the defendant reasonably believed in the immediate danger and the judge or jury concludes that that belief was reasonable. So I go to my Nana's house. I put a gun to her head and I say, Nana, you're going to write that check off of Pawpaw's checking account. You're going to sign his name. You're going to write it to me. Her conduct meets the definition of forgery, but her defense would be, I was under duress. My grandson was holding a gun to my head. That would operate to negate the state of mind that she would have needed to have. She wasn't doing it because she wanted to do the forgery. She wasn't doing it because she could benefit from it. She was doing it because she didn't have another choice. Duress. Entrapment. This happens when law enforcement tricks or pushes or somehow goads a person into committing a crime that they otherwise wouldn't. You see it sometimes with like prostitution or drug dealing. I'm walking down the street minding my own business. I'm not looking to buy drugs, but a undercover law enforcement officer comes up to me and won't leave me alone until I buy something. I finally do. Then they arrest me. I might could try to use the defense of entrapment. I wasn't looking to buy drugs. I wasn't trying to buy drugs. I didn't want to buy drugs. He came up to me and pushed them on me to the point where I just did it to make him go away. That could be entrapment. Statute of limitations. So most crimes, interestingly enough, have a certain period during which a person could be charged for that crime. And once that period runs out, they're home free. You can't be charged after a certain amount of time has passed. There are some exceptions to statute of limitations. There is no statute of limitations on murder. But most of the lesser crimes you have to be charged, arrested within a certain amount of time. And if that time period is passed, then they can't charge you anymore. Why, from a fairness perspective, would we want to have a statute of limitation? From a fairness to the defendant's perspective. What is it about the passage of time? People change. Things are forgotten. Good one, Miss Pyatt. Evidence is destroyed. Right? If we're going to, remember, we're charging somebody with a crime that could come with loss of liberty. It could come with jail time. And we don't want people to be charged 10 years down the road, 8 years down the road, and then tried based on evidence that at that point is fuzzy. Also, I would say that if the government is going to wait to charge somebody with a crime for several years, then I would say they should have charged them earlier, or else I would question why we're waiting so long to do it. Are there other motives involved? Is it political? Is it revenge? Is it personal? Are we doing it for some other reason than just seeking justice? Sometimes evidence doesn't come up or come to light until many years have passed. And sometimes the people get away with crimes because it's been too long and the statute of limitations has run and the law says the government can't charge them with the crime anymore. Immunity, we see this on TV all the time. Sometimes people are offered immunity in exchange for their testimony. So if the government has promised you immunity and they charge you later with the crime, your defense is, I have immunity. You gave it to me. Okay? You see that sometimes also with diplomatic immunity with people from other countries who come to this country and they are exempt from some of the criminal laws because of diplomatic immunity. Never really totally understood that, but I guess part of that is to keep countries from detaining or arresting officials from other countries while they're here for political reasons. I'm sure it has something to do with that. But that is immunity. So I think that I will have time to actually finish my lecture today. So I'm going to do that. Constitutional safeguards and criminal procedures. So when I'm talking about constitutional safeguards, I mean U.S. Constitution. We have something in the Fourth Amendment that says that citizens are exempt or protected from any unlawful searches and seizures. And this is another example of where the Constitution says it in a few words. But the meaning that those words have has been interpreted by courts over the centuries. We know that our Fourth Amendment protection from unreasonable searches and seizures includes they can't go in Sulpicus's backpack. The government can't come in my home at night without a warrant, right? All that doesn't, the Fourth Amendment to the Constitution doesn't say anything about law enforcement coming in my home or going in Sulpicus's backpack. But courts over time have interpreted this protection against unreasonable searches and seizures to mean that if we have a reasonable expectation of privacy in our person, in our belongings, in our home, then that can't be violated by the government unless they have a warrant. All right, so the Fourth Amendment protects us from warrantless searches and seizures. If law enforcement goes to a judge and asks for a search warrant and the judge gives it to them, then the Fourth Amendment doesn't apply to that search. Well, the Fourth Amendment does apply in that the scope of that search is limited to what the warrant says they can search. It's not a free pass to search anything. All right, if law enforcement goes to a judge and says, Judge, we have an undercover officer who's in Professor Tebow's business law class, and the undercover officer has observed him selling cocaine after class. We would like to get a warrant to search his car and his office at CSU and his backpack. And the judge says, okay, I'll give you the warrant for that. Then come search all those things from me because they got a warrant. We can sort out later whether or not the evidence that is gathered through a search warrant is going to be admissible at trial, whether or not the government can use it against us. Okay, we can sort that out later. Just because they have a search warrant, just because they execute the search warrant and they find stuff, does not automatically mean that they can use it against me at trial. There are rules of evidence that will govern what can and can't be admitted against me. Okay, we sort that out later. But any evidence gathered without a warrant is inadmissible, period. That's what the Fourth Amendment protects us from. It protects us from warrantless searches and seizures, in that anything that is obtained, any evidence that is obtained without a warrant cannot be used against us. If I'm law enforcement and I'm leadership in law enforcement, what am I telling my officers every time before we do any search? Get a warrant. Just get a warrant. Okay, the judge can sort out later whether or not we can use all this stuff. But if you don't get a warrant, and you seize evidence or you search someone illegally, we can't use it at all. So just get a warrant. A lot of the Fourth Amendment cases that you see involve the idea of whether or not there was probable cause to believe that the search would result in some evidence. That's the standard to get a search warrant. Law enforcement cannot go to a judge and say, hey, judge, I don't like the way that Tebow guy looks. He looks like a drug dealer. Can we search his office? The judge is not going to say, sure, go for it. It's not a fishing expedition. It's got to be based on some evidence that they present the judge that would make the judge think that there's a reasonable belief that the search might turn up the evidence they're talking about. You can't go and say, Tebow guy looks like a criminal. We want to search his house, his car, his boat, his office, his backpack, everything he has. All right. The search warrant is going to be tailored to the evidence that law enforcement presents to the court that they think they can find. Search warrants are obtained with just law enforcement talking to the judge. Right? There's nobody in that conversation representing the defendant or representing the person who's going to be searched. We have the opportunity to object later on to evidence that they've gathered. But that is a one-way discussion. Most everything in our justice system is set up to where both sides are heard before a judge. It's very rare. Search warrants is one of these exceptions where the judge will make a decision based on information from just one side. The search warrant is one of those times. The case that you're going to read for Thursday involves government. The law enforcement was trying to track down a bank robber. I think it's a bank robbery, a robbery of some kind. And they had some suspects, and they went and got cell phone location data from the cell phone company for these individuals who were suspects. They didn't have a warrant to get it, but they got it. They asked the cell phone company. The cell phone company gives it to them. Based on the data, they can now pinpoint these suspects of where they were at the times that would indicate they were involved in the crime, and they got arrested based on that. So the defendant's defense was, hey, them obtaining the cell phone location data was an unreasonable search and seizure. That's something I have a privacy expectation in. And if they were going to get that, they needed to go ask for a warrant first. That was how this case played out. Made it all the way to the U.S. Supreme Court. And you'll see when you read this case, a lot of the decision of the court came down to at what point is somebody's location data, at what point does that become surveillance? Like if I ask the cell phone company for 1 hour's worth of cell phone location data, is that really an invasion of your privacy? If I ask them for 2 weeks of cell phone location data and I know every single place you were for 2 weeks, that feels a lot different. That feels like I'm being surveilled. That feels like I'm being searched. And that feels like something that the government would need a warrant to have to do. So the court talks about at what point does getting location data like that become enough that we expect to have a privacy expectation and the government should get a warrant. Very interesting case, I think, for you to read. We have Fifth Amendment protections, due process of law, that's protected by the U.S. Constitution, Fifth Amendment. That means that the government can't apply laws to us unfairly. That means that we have to be given the chance to cross-examine witnesses against us. That's due process. We have to be told what we're being arrested for. That's due process. We have to the government has to give us the evidence that they have against us. That's due process. We have the right to be represented by an attorney. If we're denied that right, that would be a denial of due process. Due process encompasses this idea of fairness within the process. Okay? I can't be sent to jail without a trial. That would be a violation of my due process rights. Double jeopardy, can't be tried for the same crime twice. So if I am tried for a crime, I go to trial and I am acquitted, found not guilty, then they cannot try again. They don't get to rearrest me and get a do-over of that trial. Self-incrimination. This is the right. This is when you say, I plead the fifth. This is if you're under oath or you're being questioned by law enforcement, you have the right not to answer a question if you think it might be incriminating, that the answer might result in you having some sort of criminal responsibility. You have the right to remain silent. The Constitution also talks about that evidence that is obtained illegally cannot be used. So when I said that if the government, law enforcement, got evidence against me in a search that was unlawful, they didn't have a warrant, they can't use it at all. All right? And so not only can they not use whatever they found illegally, but they can't use anything else that they found as a result of the illegal evidence that they found. I'll give you an example. We call that fruit of the poisonous tree. All right? If they search my car after class without a warrant and they find all kind of drugs, they find all kind of evidence of other crimes, all right? If that search was illegal, then anything that they found in the search is out, is excluded. Nothing is admissible. Doesn't matter what it was. It's another reason that if I'm law enforcement, I'm telling my folks to get a warrant. Because I don't want to have a situation where the judge says, well, sorry, you can't use any of that. My case falls apart. Now, I do want you to appreciate this. There are some situations where the government doesn't have to have a warrant. I'm not testing you on those. We're not going down that rabbit hole necessarily. But in emergency situations, or if evidence is in, it's called plain sight, if there is a health risk at a restaurant, there are times when the law makes exceptions to when they can do a search without a warrant. And if the parties disagree on whether or not they should have had a warrant before they do it, then they'll go see a judge and they can hash that out later. But there are some situations where warrantless searches are allowed. Again, not asking you to know the difference between those. Question?
So even if someone's like proved guilty, like if you got it illegally, like
Yeah, if the evidence is smoking gun evidence, like a confession, but it was obtained illegally, out. Can't use it. Yes.
what if like one police officer finds this illegal evidence and tells his coworker or another police officer get a warrant?
So you can't get a warrant based on evidence that you obtained illegally. Yeah, so I see what you're saying. They can't get around it that way. If they got any information and it turns out that they should have had a warrant, everything that flows from that is out. It's all fruit of the poisonous tree. That's why we have our Miranda warnings. You have the right to remain silent. You have the right to all these things that that the law requires that you're read when you're arrested. If you're not read those rights, and then they interrogate you and you confess all that, but you have not been read your rights, then all of that is out. That's fruit of the poisonous tree. If the search was illegal, then anything they find is illegal. Good questions. All right, that's all I have for you today. Read your case for Thursday. And if you came in late, let's see, Miss Battistini, I got you. Mr. Bernard, got you. Mr. Eason, got you. Mr. Green, I don't see Green. Hoffa, I do not see. Latrell. Miss Hackett. No Miss Hackett today. Mr. Wynn. No Wynn today. Mr. Nixon. We had Nixon? No Nixon. I got Miss Pyatt. And I got Miss Stewart. I don't have Mr. Spalding. That's everybody. Yes, ma'am. Oh, you're good. I got you, Mark. You're here.
Oh, and then I was gonna ask you. So the last.
It was a quick dentist appointment.
I went early, so I can figure out something. But I got there about 9:15. But it was
Impressed.
just an orthodontist check. Maybe how hard would it be for me to pass? I missed the last 2 weeks of April and just do it online.
I'll let you do it. That'd be fine.
Emergency knee
That'd be
replacement.
fine.
So I'm just trying to figure out.
Not a problem at all.
Okay.
We can do it 2 ways.
I don't know that I'm gonna have to do it.
Yeah,
So
I'm just thinking, I can always give you an incomplete. You have a whole year to finish that. Or we could you could do it ahead of time. Let's talk about, yes, we'll figure out a way.
Yeah, that's
Yeah.
I'm not 100%.
Happy to figure out a way on that.
Thank you.
Yep. Yes, sir.
I think I just need a little more information about the like justification one,
Yeah.
because I can't remember,
Yeah, I'm interested in that.
but it was some kind of hurricane. I want to say it's somewhere in either Georgia or Florida that I heard about it. But there was a hurricane on the way, and people were like out in the street, and they were trying to get into buildings, and a lot of buildings they found were locked. And then they came upon the gas station, which was also locked.